The Fifth Circuit decision, which found that suppressors are not arms and therefore don't trigger 2A protections, is now once again up for review. And now the Trump DOJ has changed their position on suppressors, and they agree that suppressors are protected arms and that an outright ban is unconstitutional. This is now giving a lot of support to get the Fifth Circuit to finally greenlight review of this case and take it en banc and finally strike down the NFA and its restrictions on suppressors. So this is very interesting, so let's break down what is happening. Now, before we jump into this video, I just want to mention that if you guys want to support the channel for free, please consider subscribing to the channel. That, of course, helps the channel to grow. Drop a positive comment down below because that tells the algorithm that you appreciate this type of 2A content. And then also, I'm going to leave a link down below to my podcast and the podcast I do with Johnny and Jared, the Liberty Lounge. We love your guys' support over there. We're going to be releasing more episodes and a lot of stuff. And also, you can get all of my videos here on audio format. If you go over to the Liberty Lounge, we're going to be uploading the individual videos here on the main channel, also on the audio only form. So if you want to listen while you're driving or whatever. Now, as I mentioned in the intro, in this video, we're going to be discussing a suppressor challenge that was ruled on by the Fifth Circuit 3-judge panel, and it's now currently heading to the Fifth Circuit en banc panel. And here you have the plaintiffs, Mr. Peterson and FBC, asking for the Fifth Circuit en banc panel to take this case and strike down the NFA's restrictions on suppressors. The case we're going to be talking about is U.S. versus Peterson. In this case, Mr. Peterson challenged his conviction of violating the NFA based on a theory that the NFA and its suppressor restrictions do in fact violate the Second Amendment. And on review, a 3-judge panel in the Fifth Circuit found that suppressors are not arms, and because of that, they do not trigger 2A protections. However, now the Trump DOJ through AG Bondi have stated in their new brief to the Fifth Circuit en banc panel that suppressors are arms and that they cannot be outright banned even by states or the federal government. And at the same time, they argue that the NFA's restrictions do not amount to an outright ban, and therefore it's consistent with the Second Amendment. However, the caveat with all of this is that they're still arguing that the Fifth Circuit en banc panel should take this case on review and reverse what the lower court said and essentially do away with the rationale in the analysis that suppressors are not protected arms. This was a major shift on suppressor restrictions. The DOJ and the federal government have changed position when it comes to suppressors, and now FBC and Mr. Peterson are using that in this case to seek Fifth Circuit en banc panel review, and they're asking for the Fifth Circuit en banc panel to strike down these suppressor restrictions. Now, in this case, back in 2022, both federal and state law enforcement officers executed warrants at Mr. Peterson's home in Louisiana. A federal task force included ATF agents and about 50 other law enforcement officers who served a search warrant at his home. He also had kind of a home-based FFL, I believe in a building that was attached kind of to his home or on his property. And they executed those warrants, and they claimed that there were issues with straw purchases, improper record keeping, some violations of some 4473 forms, failure to complete some transaction forms to the ATF. And then there were also issues related to some products that he sold being found at crime scenes, and they tried to tie that to Mr. Peterson and potential straw purchases as well. But out of this entire situation, it's the possession of a single solvent trap that was not registered under the NFA that led to the conviction and the challenge in this lawsuit. In response to this charge against Mr. Peterson and his attorney at the time filed a motion to dismiss the charge based on the Second Amendment. And on review, the lower court denied his motion to dismiss the indictment and the charge against him, and that led him to then go to the Fifth Circuit to a 3-judge panel, and he asked them to reverse the decision down below. However, on review, a 3-judge panel in the Fifth Circuit sided with the ATF and the DOJ, and they found that Mr. Peterson's motion was properly rejected and that the Second Amendment does not protect these types of items and that suppressors are not protected arms. In the ruling, the Fifth Circuit stated that whether suppressors constitute arms is an issue of first impression in our circuit. And so far as we can tell, every court to have addressed it has decided the question in the negative. Here, the Fifth Circuit looked at whether suppressors are a weapon of offense or an armor of defense, or are they used to cast at or strike at another? And the Fifth Circuit incorrectly found that they are not. They stated that Peterson posits that suppressors are an integral part of a firearm and therefore warrant Second Amendment protections. But that is wrong, they stated. A suppressor by itself is not a weapon. Without being attached to a firearm, it would not be of much use for self-defense, and unless a suppressor itself is thrown, it cannot do any casting or striking. The Fifth Circuit went on to find that suppressors are not a necessary accoutrement of a firearm, and they're not required to actually make a firearm useful or operate or to make them functional. And based on that, they upheld what the lower court said. Now that inherently is concerning, and it's a concerning decision coming out of the Fifth Circuit, where the Fifth Circuit is saying that suppressors are not protected arms, but that has now led Mr. Peterson and his new counsel FPC to seek a rehearing of that decision en banc in the Fifth Circuit. Now, originally, after the transition from the Biden administration to the Trump administration, there were potentially some holdover attorneys who were still arguing that the rehearing should not be granted, and they continued to agree with what the Fifth Circuit had said prior, that suppressors are not protected arms. However, now there has been a drastic shift, and the Trump administration filed a new brief saying that they do not agree anymore, and that suppressors are protected arms, and that an outright ban on their possession would be unconstitutional. In the new brief of the DOJ, they argue that as part of its broader evaluation of its litigating positions in Second Amendment cases per the executive order of Donald Trump, the United States has reevaluated its position in this case. In the view of the United States, the Second Amendment protects firearms accessories and components such as suppressors. As a result, restrictions on the possession of suppressors burdens the right to bear arms, and a ban on the possession of suppressors or other similar accessories would be unconstitutional. The government's earlier argument to the contrary was incorrect, but the NFA's registration and taxation requirement is constitutional because it imposes a modest burden on a firearm accessory that is consistent with the nation's historical tradition, because suppressors are specifically adaptable to criminal misuse. For this reason, they stated, the panel correctly affirmed Peterson's conviction. Accordingly, although rehearing en banc is unwarranted, the court should grant panel rehearing to correct the panel opinion's analysis. The goal of the DOJ with this brief may be to get the en banc panel to take the case and find that suppressors are protected arms, which would create a critical circuit split. And maybe also in the process of the review, also you can get the en banc panel to find that the NFA does in fact violate the Second Amendment, and you wouldn't really even need the DOJ itself to argue that if you can get the en banc panel to review this case. Now, after the DOJ's new brief, FBC and Mr. Peterson recently responded to that, and they argued that the government's letter brief confirms that this court should take this case en banc. The panel in this case held that restrictions on firearm suppressors do not implicate the plain text of the Second Amendment. The government now disagrees with that holding. The full court now has an opportunity to correct the panel's error and bring the court's precedent in line with the prior understanding of the Constitution on this vitally important question. The government suggests that the panel could avoid en banc panel rehearing by following the government's lead and finding that suppressors protected by the Second Amendment, but it does not explain why the panel would change its position simply because the government has. And while Mr. Peterson would welcome such a change, the question is important enough to warrant the full court's attention. What is more, while the government now properly recognizes that the NFA's taxation and registration scheme for suppressors implicates the Second Amendment, it seeks to salvage its conviction of Mr. Peterson by arguing that the scheme is consistent with the nation's historical tradition of firearms regulations. Like the question whether suppressors are protected by the Second Amendment, the question whether protected arms may be subject to taxation and registration is a vitally important one, deserving the attention of the en banc panel court. So now you have both Mr. Peterson, his attorneys, and the DOJ saying that the en banc panel should take review of this case, at least on the issue of whether or not suppressors are protected arms. And both sides are saying that the three-judge panel in the Fifth Circuit got the analysis wrong and it needs to be corrected. That review could also lead to a finding that the NFA is unconstitutional, despite the DOJ saying that it's still a permissible restriction and it doesn't go so far as to create an outright ban. Now, this is very interesting. It's an interesting shift in this case, which makes it more likely that the Fifth Circuit en banc panel will step in and take review of this case. Even if they don't, that then primes this case to go to the Supreme Court. And that would be interesting because at that time, if this gets to the Supreme Court, you would still have Mr. Peterson, his attorneys, and the federal government both arguing for Supreme Court review and a reversal of what the lower court said, essentially a review of whether or not suppressors are protected arms. Time will tell how that kind of plays out, but at least in this case right now, both sides are saying that the Fifth Circuit en banc panel must review this case and review this issue of whether or not suppressors are protected arms. Again, very interesting case, and it shows how important it was that the Trump administration, of course, has control of this, and how the new two-way task force is stepping in to change some of the arguments in these critical challenges. So it's going to be interesting to see how this develops and if the Fifth Circuit en banc panel decides they want to step in. And regardless, this is one of those cases that will eventually probably make its way to the Supreme Court. So as it develops, as we get more information, I will let you guys know. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.